My name is Nelson Kari. As I have been so aptly introduced, I am a lawyer and a software engineer. I've been an advocate for 3 years and a software engineer for 6 years. So I combined 9 years of experience in both fields. I practice law at Nelson Kari and Company Advocates, and my law firm is a member of the prestigious Lexing Network, which is a global association of lawyers and law firms that are specialized in digital and emerging technologies law. And our membership stretches to 48 countries across 5 continents, so we are globally connected, offering services in digital and emerging technologies law. Our discussion is about how we can prepare African courts for smart contracts, artificial intelligence used by the bench. Yes, preparing African courts for digital evidence, smart contracts, robo-lawyers, and the use of AI by the bench. So we've had all these discussions about disruptions, what we can expect, what we need to do as far as regulation and development of laws to govern the sector. So now that we are anticipating, or rather we are experiencing these disruptions, what do we need to do to ensure that our courts are aptly prepared to deal with this disruption that's coming about, not just from artificial intelligence, but also from other technologies such as blockchain, which is the basis for smart contracts. So the overview is basically how we can prepare for all these technologies that are eventually going to find their ways into our courts. So the use of AI is no longer a futuristic idea. It's something that we used to hear about a few years back, but now it's something that is a clear and present, I don't want to call it a danger, but it's something that we actually have to objectively deal with at this moment in time. So we have seen innovations for AI-powered legal tools. I think we had some presenters here speaking about their innovations and what they do. And we have seen these tools being implemented across various jurisdictions. We have our e-filing system. Other countries also have their innovations that they use for court proceedings. And what we're going to do in this presentation is assess the current state of readiness in our judicial systems, highlight some critical gaps, and offer practical context-aware recommendations. So what is digital evidence? Digital evidence is any information that has probative value. I'm sure lawyers know what that means. Probative value and transmitted in a binary form. Smart contracts are self-executing digital contracts, and they are built on top of distributed ledgers, that is blockchain technology. And finally, robo-lawyers are AI assistants or AI-powered legal tools that perform routine legal tasks. I'm sure we've heard about these. I think at some point in time, there was an American company that was very loud about how their robo-lawyer is going to represent someone in court, the success of which did not actually come to fruition. There was a legal challenge to that, and that did not happen. But these are things that we are seeing being innovated and coming to the fore more and more frequently. So what is the current state of legal tech in African courts? So across the continent, many courts and judicial systems have been digitizing their workflows. We've seen that this has come about as a result of many factors, COVID-19 being perhaps the biggest influence. There's also the issue of rising caseloads and the demand for more accessible justice. Some of these technologies include case filing, case tracking, case management, virtual hearings, and online dispute resolution. Some statistics on the current state of legal tech in African courts. Next slide, please. Yes, so we have various countries having taken up different kinds of legal tech solutions. For example, online dispute resolution in Rwanda, being piloted in South Africa, Ghana, Malawi, Sierra Leone, Cote d'Ivoire. We have e-filing and case management in Kenya, Uganda, for instance, virtual court hearings in Kenya, Tanzania, the COMESA court as well. AI tools being used for transcription, for instance, in Egypt and Morocco, and digital evidence being presentable in court in Kenya, Ghana, South Africa, Nigeria. And so, what are the key issues that African courts now need to take a look at in order to be prepared for this tech revolution? So, the integration of tech and AI presents legal, procedural, and ethical challenges for African courts. So, remember, we do not need to sacrifice procedural fairness at the altar of efficiency. And so, what is it that we need to really take a keen look at before we can effectively integrate these technologies into our courts? First and foremost is the technical infrastructure. Without investing in nationwide technical infrastructure, it's going to be difficult for these technologies to have the impact that we desire from them. It's essentially a risk that if the technology infrastructure is not sufficient, we are just going to exacerbate inequality. Remember, there's a digital divide. Urban areas such as Nairobi have access to consistent electricity and technical resources that perhaps rural areas may not be able to access. And so, if the technical infrastructure is not nationwide, then we are at risk of exacerbating inequality. Number two is judicial capacity, and this was mentioned in the morning session. There's a need for training, intensive training within the judicial training institutes to build capacity amongst the judiciary staff, and this training needs to be continuous in order for our judicial staff to be able to understand not only the technologies but also the legal doctrines behind them. We've had a discussion about the laws and the legislative frameworks. From yesterday's AI regulators roundtable, the one key takeaway that I got was that it's not just enough to build a governance framework. It has to start from a policy framework, because if you're building a governance framework without a policy framework, then you're at risk of stifling innovation. And so we need to figure out how to modernize our legislative frameworks in such a way that we are satisfying the needs, for example, of procedural fairness, but at the same time not stifling innovation for our techies. There's also the issue of the digital divide or inequality that I've spoken about. We also need to figure out how to build public trust, and any successfully integrated digital system has to be trusted by the public. If the public does not feel that the courts if the public does not feel like a technology has their trust, then they're not going to actively engage in whatever solution that you're going to offer to them. And so our courts have to proactively build public confidence in the digital systems that they're going to integrate. And finally is data governance and sovereignty. We've covered this at length in the previous discussion. So how do we get ready? What does the readiness framework look like? Our readiness framework will cover how to equip the courts with the legal, institutional, and technological tools that are necessary to integrate these tech platforms into their workflows. First and foremost is legal policy and reform. We've discussed the need to update our laws and regulations to essentially rise to the occasion. This should include a review, an audit rather, of the existing laws to identify where they fall short, and where legislation is outdated or silent, perhaps judicial practice directions can provide immediate guidance. And it's a fact of life that technology will always outpace the development of laws and regulations. And so we need to be alive to that fact and perhaps develop frameworks that are forward looking and not as restrictive in nature so that they are adaptable to the rapid changes that we are seeing in technology. Number two is capacity building. So once we have the legal frameworks in place, we also need to invest in building the capacity of magistrates, clerks, judges, and other judicial staff, updating the curriculum of judicial training institutes to cover topics that are relevant to legal technology, and also extending this training to court users and ensure that litigants and lawyers are able to navigate the new digital processes. We also need innovation through partnerships, um, through carefully structured PPPs, public-private partnerships. We can accelerate the development. We know that we have a capitation or a capital problem, and so a way out of this is public-private partnerships, working with institutions that can provide the technical and the financial resources that we need um, to build this infrastructure that we're talking about. And this is going to require strong governance because we want to avoid situations such as vendor lock-in and ensure that there's accountability and we have preserved our judicial independence. Finally, regional cooperation and harmonization. It's important that we do not build these solutions in silos. We need to harmonize our standards and share best practices. We have many regional blocks such as ECOWAS, SADC, and EAC that can support the development of model laws, regional judicial training frameworks, and interoperable digital infrastructure. So we need not be so focused on digital sovereignty to the extent where cross-border issues that arise, for instance, with smart contracts, are not able to be properly adjudicated because we have built ourselves into a silo and we are not able to break out of that and resolve the problems that are arising from electronic justice across the border. And so, my final thoughts on this justice systems must not only catch up with technology, but we need to learn to lead it. If justice is inaccessible, outdated, or uninformed, then it's justice denied. And we don't need to just focus on digitizing what exists, but also shaping the future by designing systems that are faster, fairer, and more inclusive. Thank you very much for your time. I hope you enjoyed my presentation and learned something. Am I taking any questions?
My question, I'd like you to think with your technology brain on this one, since you're in the same space as myself. Because the challenge I've always had with the issue of regulation and laws is the aspect that the need when you start with regulating and saying all these things are good. At what point do we draw the line on over-regulation? Because it's something that's very common. Since you both in the legal space and in the software development space, you know for a fact that when you're developing and you're coding and all these things, you want this space to be able to come up with a tool or a program that will benefit people. So if we're putting the cart before the horse, you're already coming up with regulations. How do then us who are developing these tools still innovate, because their regulations and their policies are oftentimes drafted when we are not in the room. Then the disconnect is completely there all the time. Then the other thing I wanted to add is while you're making your presentation, is up here we have like an e-filing system. It's still in its infancy stages, but we'll get there.
So on your question of putting the cart before the horse, I struggle to see a situation where we've had regulation, especially in the tech space, regulation coming before the actual product. Let's take the example of artificial intelligence. We've had artificial intelligence. It's been a concept since the 1970s, I think. And now is when it's come to full fruition. And we are yet to actually see an AI regulation, for instance, for Kenya. We've only seen an AI, the EU AI Regulation Act last year or this year, if I'm not wrong. So the development of technology will always outpace the development of laws and regulation. Perhaps what might be a challenge, or what you may have experienced, is the fact that we have not yet perfected artificial intelligence, but here we are scrambling to regulate it. And we are scrambling to regulate it because we have already seen the potential for harms. And so, like I said in my presentation, there really isn't anything that we can do to make sure that our laws are not falling behind the development of technology. But when we institute, or rather, when we bring about laws and regulations for these technologies, we need to make them in such a way that they are not rigid to stifle innovation. And this can be achieved through policies. So we start from policies. A policy is forward looking, it's 5 or 10 years in the future. Where do we want to be 5 to 10 years from now? So with that policy, then we build regulation and laws around that, knowing that this is where we want to go. So we are not actively stifling innovation with the laws and regulations that we're putting in place.
My name is Morgan Maina from Hacky Chain, where we are building solutions empowered by the blockchain. Mine is just a question because majorly I've seen the conversation that is happening today is around AI. And I believe blockchain is a technology that is emerging and has a great potential and needs to be heavily adopted. My question is if the government and the legal people in the legal field are willing to accept blockchain technologies and integrate them in their solution. Oh, thank you.
Thank you. So my question, of course, is also closing out the festival. Taking an assessment of what we've done so far, and especially with looking at the sort of ideal of how it's meant to look like or how it should be. And following up on just your presentation, what would you say in terms of what are we solving for? And in that specific instance, what are this sort of frameworks or like rubrics that we can say can or can't work that will enable us to measure our success while implementing sort of regulation and innovation in especially focusing on AI going forward?
Okay. So the first question, the effectiveness or the adoption of any technology really is reliant on fitness for purpose. So if the technology is fit for purpose, then definitely it's going to be adopted even by the government, as you had asked. On the second question as to what we are solving for, let me take a broader picture. Our discussion has been on disruption, and generally we've seen the disruption that's come about from artificial intelligence and these other emerging technologies. So your question as to what we are solving for. Right now it's like the Wild West. Someone somewhere made their submissions to court with made up proceedings. We're in the Wild West. As a lawyer, I want to use perhaps artificial intelligence to make my work easier or more efficient, but there's really no framework in place to govern what I can and cannot do. There's nothing as far as the law is concerned to tell me that this is the path that I need to follow. So that is what we are solving for. So how we are going to measure success? Our success can be measured first and foremost on reducing the potential for harms. So identifying at risk, let's call them populations, who is at risk of losing the most if this goes on unchecked. So that's perhaps the biggest thing that we can look at as a KPI or as a measure for success. I think I should stop there. Yeah. Thank you very much for your time and your attention.